All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Please be seated. Good morning. I'm Chief Justice Tom Parker, and on behalf of the Supreme Court of Alabama, I welcome you here to this morning for this special oral argument session. As you may know, most of our oral arguments are held in the beautiful judicial building in the capital city, Montgomery. Hopefully, many of you have already toured that as students, but often twice a year, we will take one of these oral arguments on the road so that the public can see what we do. And for the first time in decades, we are thankful to be back at Auburn University and at the wonderful Gouge Performing Arts Center. Briefly, I wish to thank those who have helped make today's events come together, and then introduce the members of the court. First and foremost, we wish to welcome all the students who are here in attendance, students of Auburn University and students from nearby high schools. We hope today's court session is educational and inspirational to you as you observe in real time what we do on the court. This is your Supreme Court, and for those of you who may go on to law school, you may find yourselves arguing before this court sometime in your career. So pay close attention. We wish to also thank the professors for letting your students skip class today to attend. To the leadership of Auburn University, including President Christopher Roberts, thank you for your gracious hospitality both last night and today. For their remarks this morning, I wish to thank Associate Provost Dr. Norman Godwin and presiding Lee County Circuit Court Judge Christopher Hughes and Judge Richard Minor of the Court of Civil Appeals will give you a brief concluding remark after our argument and before you're dismissed. For all the behind-the-scenes work by the excellent professional staff that have coordinated so well with our clerk of the court and our court staff, a big thank you to Julie Huff, Tracy Newell, and Maddie Vines. We also wish to honor and thank Associate Director Mike Adams and the campus safety and security team here at Auburn, Officer Keith Walton and Captain James Pescia and Lieutenant Reed Chambers of the Auburn Police Department, and all the officers who are attending and providing safety and good order for us today. From beginning to end, the exceptional team here at Auburn University have been highly professional and organized, and the success of today's event is largely due to you all and your excellent cooperation with our staff. Please join me in thanking all those responsible for this, for what they have done to put this together. And now it's my distinct honor to introduce all the members of the court. And to my right is Justice Greg Shaw of Davison, a graduate of Auburn University. To my left is Justice Kelly Wise of Prattville, also an Auburn graduate.
War Eagle.
To Justice Shaw's right is Justice Tommy Elias Bryan of Brantley. Justice Bryan was recently elected as the Republican nominee for re-election to another term on the court, and he has no opposition in the general election. To Justice Wise's left is Justice Will Sellers of Montgomery. Justice Sellers was also elected as the Republican nominee for a new term on the court, and he has no opposition in the general election. To Justice Bryan's right is Justice Brad Mendham of Dothan, another Auburn graduate. To Justice Sellers' left is Justice Sarah Hicks Stewart of Mobile, Justice Stewart was elected the Republican nominee for Chief Justice, and she has opposition in the general election. And to Justice Bryan's right is Justice Jay Mitchell. I can't even see Jay, you're leaning back so far. He's of Homewood, and he was also elected as the Republican nominee for a new term and has no opposition in the general election. And Justice Greg Cook of Vestavia Hills is not sitting today. He's recused from this case. And as I mentioned earlier, I'm Chief Justice Tom Parker of Montgomery. And I will add that I'm married to an Auburn native and an Auburn graduate. At this point, I want to take a point of personal privilege. I'd like to note that this is my 6th and final year as Chief Justice. This is my 19th going on 20 years on the Supreme Court. But because of Alabama's Constitution, there's an age cap for justices, and I will not be able to run again. That's why I was introducing Sarah Stewart with her success at running for Chief Justice to follow me. And I'm required to retire at the end of this term in January of 2025. It has been a great honor to serve the state of Alabama as your Chief Justice. And like a retiring head football coach, I will continue to root for the success of our team, the Unified Judicial Team. I'm also glad to recognize our Clerk of the Court, Megan Rodebeck from Montgomery, and our court staff who's been helping her is Chelsea McLaurin, and our clerks in the clerk's office. And we have our IT team here to help us today with Robbie Headley and Jaquil Kemp. Last but not least, we want to thank our marshals from the court. That's Marshal Earl Marsh and his team with Chief Deputy Marshal Chris Coley and Deputy Marshal Perry Moore, and for all their work in organizing this and protecting us today. Now, a word to those of you attending today, particularly for the high school students. What you'll hear are arguments on a petition for writ of mandamus. Mandamus is a Greek word, but for those of you who've studied Spanish, you might know the Spanish word mandar. The verb to send is typically used, but it also means to order or to command. And so that will give you some insight to what you're going to hear today. This is not an appeal which occurs at the end of a trial, but this is a mandamus, a challenge to a preliminary ruling by the trial court judge. And so the terminology changes for the parties, whether it's a writ of mandamus or an appeal. So here today on a mandamus, we're going to have the petitioner followed by the respondent to the petition. Now, we give them equal time, 30 minutes for each side, but the petitioner goes first, followed by the respondent. The petitioner is able to reserve some of their time for a response, and that has occurred today. So with that setting of the stage, I call on Madam Clerk to call the docket for us.
In case number SC 2023-0601, Ex parte Jackson Hospital and Clinic, Incorporated. Arguing for the petitioner, Jackson Hospital and Clinic, the Honorable Thomas Ritchie. Arguing for amicus curiae, Governor Kay Ivey, the Honorable Will Parker. Arguing for the respondent, Theresa Johnson individually and as executor of the estate of Nathaniel Johnson, the Honorable Robert Lemoyne, and the Honorable Will Lattimore.
Mr. Ritchie.
Mr. Chief Justice, and may it please the court, my name is Thomas Ritchie, and I'm here today to argue on behalf of the petitioner, Jackson Hospital. With me is Will Parker, the governor's general counsel. Jackson Hospital is immune from the non-wantonness claims of the plaintiff under both the governor's emergency proclamations that were issued under the Emergency Management Act and is independently immune from those claims under the Alabama COVID-19 Immunity Act passed by the legislature in February of 2021. Both the
Mr. Ritchie,
Yes.
In your brief, you did not raise the issue of immunity under the governor's proclamation. Are you changing your argument now?
Your Honor, Mr. Chief Justice, our petition was addressed to the trial court's order, which did not reach the issue of validity. We raised the issue in our petition of the construction of the Alabama COVID Immunity Act. That issue has since been decided by this court in the ex parte triad case in a manner that would require granting our petition. The issue of validity was not raised in connection with our petition until the respondent's brief was filed, and we've addressed those issues in our reply brief. Both the proclamations and the ACIA are valid and enforceable, and each independently provides immunity against the non-wantonness claims asserted in this case. The proclamations and the ACIA demonstrate the proper functioning of government in an emergency. The COVID pandemic caused an unprecedented level of uncertainty across this state, affecting its healthcare industry in particular, but every aspect of its economy. And the governor and the legislature worked together proactively to address this emergency in a manner that protected the health and welfare of the people of this state. Both of these enactments immunize Jackson Hospital. In fact, this issue is so clear that no longer is it the scope of immunity that is at issue, but it is the validity of immunity. And even more precisely, it is the timing of immunity that is the sole issue that remains before the court. And that is so because the respondent has challenged whether the governor had the authority to issue prospective immunity through the emergency proclamations under the AEMA, and she unquestionably has that authority. Also before the court is the question of whether the legislature could retroactively grant immunity through the ACIA, and again, it unquestionably does. I will begin with the proclamations and the AEMA.
Counsel, could I interrupt you?
Certainly.
1 second. I want to jump to the constitutional issue. I noted that, well, first of all, I would appreciate it if you could clarify for the court the procedural posture of this case below. You make the argument, and I don't know if it's an argument or just a hint, that this constitutional argument concerning the retroactivity, Section 13 of the Constitution, perhaps may have been waived by virtue of the respondent's preparation of the order. I mean, that was something y'all said in your reply. I would like to hear some discussion of what went on in the trial court, how that order came to be, what your position is on the effect of that order. I would also like for y'all at some point to discuss the posture we have on appeal as to this issue. You did not argue in your petition about the retroactive constitutionality issue, and you do not argue it in your reply brief. So up here now, I don't see any argument in rebuttal of the respondent's argument below or in their answer. So are we in a situation now where we are perhaps looking at affirming on an alternate basis? Can we look at the amicus briefs for a responding argument to the argument, the only argument that has been made? Have y'all abandoned that argument by not raising it at all? I would like for you to set the stage for us on that constitutional issue, please.
Certainly, Your Honor. I will begin in June of 2022. At that point, the trial court issues summary judgment on immunity grounds for Jackson Hospital. At that time, there had been no constitutional issue raised, and the affidavit of the plaintiff that the plaintiff alleges to create the issue of material fact in this case had not been submitted to the court. The plaintiff had sought and been denied Rule 56F relief, and the summary judgment record was closed. The trial court granted summary judgment for Jackson Hospital on immunity in 2022. In July of 2022, the plaintiff seeks Rule 59E relief and attaches for the first time the affidavit that is in the record before the court. The case is on Rule 59 until November and then ultimately until March of 2023 as the hearing is extended on that Rule 59E motion. It's either February or March of that year, the plaintiff for the first time raises a constitutional challenge to the statute, a challenge that was available to the plaintiff at the time of summary judgment but was not made. The court hears Rule 59E argument and elects to permit, in August of 2022, the court permitted depositions to take place of the affiants that Jackson Hospital had relied upon in connection with its original summary judgment. Those witnesses testified consistently with their affidavits. That was the sole purpose for which Rule 59E relief was originally granted, was the taking of those depositions. And it's a form of Rule 56F relief that was granted after the fact. Eventually, in February or March of 2023, the plaintiff makes for the first time a challenge to the constitutionality of the statute. That issue is fully briefed both by the parties and by amici. The governor files an amicus brief, as does the Business Council of Alabama, speaking on behalf of other organizations as well.
Can I stop you there?
Certainly.
Has the trial court had an opportunity to address the constitutionality issue?
The issue was before the trial court, but not ruled upon. The trial court ultimately revisited its summary judgment opinion and did not reach the constitutional questions, which is why they were not raised in our petition.
Do you have any case law or authority to follow with Justice Shaw that if a trial court gives a party, the plaintiff, additional time to present evidentiary material, that they can't raise any issue, including constitutionality?
No, we don't have any, there's no point of law that would say that. I believe that it is within the trial court's discretion to allow that, though I believe that all those issues were available and could be found waived as not being raised at the original time of summary judgment.
But you don't have any authority that supports that, or?
Not before me, Your Honor.
Thank you.
So I'm sorry.
Did you argue that the plaintiff had waived this issue? I mean, because it appears that, have you waived that issue because you've addressed the merits?
It was our intention, Your Honor, to advance this case to a resolution on the merits, and so we did not attempt to argue waiver in the trial court, no.
What do you think the trial judge ruled on? I know there was a request that counsel submit an order. That's commonly done in Alabama. An order, a proposed order, was submitted to the trial judge. The trial judge apparently signed off on that order. That order says nothing about the constitutional issues that y'all argued to him. That's a pretty important issue. So I guess your position is, had he considered it, he would have said something about it, but he didn't. So what is your take on his ruling? Did he go straight to 793 and essentially find an exception to immunity under 793, disregard 792, 794, and just hold that exception in 793 prevented immunity under any section?
Yes, Your Honor. Our contention is that the trial court treated the COVID Immunity Act as valid because it construed the statute. It expressly did not reach any question of validity. It expressly said so in the final sentence of the order, and that the trial court misconstrued the statute by saying that if there was a claim for wantonness, that claim would necessarily fall outside of Section 93. And if you were outside of 793, you could not be within, in the trial court's mind, 792 or 794. We believe that that's an error and inconsistent with this court's judgment in Triad. I see that my time has expired.
Thank you. Mr. Parker.
Good morning, Mr. Chief Justice, and may it please the court. My name is Will Parker, and I represent Governor Kay Ivey as amicus curiae in this case. I currently serve as Governor Ivey's general counsel, and it's a position I've held since December of 2019, which means I was personally present on March 13th, 2020, just 3 years ago yesterday, when the governor proclaimed a state of emergency for the COVID-19 pandemic. It means I was also personally present when she signed the Immunity Proclamation and the Immunity Act at issue in this case that helped Alabama be a leader among the nation in reopening the economy coming out of the pandemic. And it means I was personally present for each of the 18 long months during 2020 and 2021 when our state was in a state of emergency for the pandemic, and our governor had to make tough decision after tough decision to help this state navigate what was once in a century public health crisis. Today I'm here at Governor Ivey's request not only to defend the legality of the Immunity Proclamation and the Immunity Act, but also, and more importantly, to underscore the seriousness of what's at stake in this case, the importance of this governor or any other governor's powers under the Emergency Management Act of 1955 to both the state and to its people. The best way to understand what is at stake here is to look at how governors have relied on the Emergency Management Act in the past. And it's no stretch to say that governors have used this act to save lives. As we explained in our brief, Alabama governors have issued orders during hurricanes to help refugees receive emergency prescription refills. During winter weather, Alabama governors have issued orders to help expedite the delivery of propane heating gas. And during the 2011 tornadoes that ravaged Tuscaloosa, the governor issued an order granting temporary licensure reciprocity to social workers to help our citizens more easily and more quickly get access to needed shelter and services and food and other important items. Even our boilerplate, off-the-shelf ready emergency proclamation that we might use in, say, a tornado or a hurricane contains provisions to authorize the ALDOT director to waive various requirements such as height and weight restrictions that would ordinarily hinder the flow of emergency equipment and supplies across the roads and highways. The point is that in each case, this law from 1955, the Emergency Management Act, is there in the background, behind the scenes, empowering the governor to cut through legal red tape and take necessary actions that would otherwise be impeded by law. The COVID-19 pandemic just put a big exclamation point on the importance of these powers. This was not an emergency that affected thousands of people from some terrible one-time event. This was an emergency that affected all 5 million Alabamians, at least in some way, on a long-term, constant, and dynamic basis. I want you to recall just for a minute the fear and the uncertainty that caused so many people in this state and around the nation to skip haircuts, to wash hands constantly, to stay 6 feet apart, to even leave your mail in the mailbox and sanitize it before bringing it into the house. Faced with that kind of reality and that kind of uncertainty and fear, Governor Ivey issued ultimately 28 separate emergency proclamations during this pandemic state of emergency, and those proclamations contained some 60 discrete emergency actions.
Mr. Parker, do the governor's proclamations have any bearing on these mandamus proceedings, given the scope of the arguments that the Jackson Hospital made in their petition?
Yes, Your Honor, I believe, and I want to make clear up front that I'm here today to urge the court to not needlessly call into question the validity of this proclamation. That's my number one goal. But I do believe that this proclamation, which was issued in May 8th, 2020, would have the effect of precluding certain of the claims brought in the particular case. I will certainly let the hospital talk about the specifics of those claims on rebuttal if necessary, but my understanding is that the claims, at least some of the claims brought by this particular petitioner, would be barred under the proclamation that was in effect at that time.
But doesn't Jackson Hospital have to allege that the governor's order relates to this? Something that there's a question about whether or not they have actually alleged that?
So my understanding, again, I'm here for the institutional prerogatives of the Office of Governor to defend the validity of this proclamation. But my understanding is that this issue was presented below. Again, I would be happy to let the hospital discuss the actual procedural merits and demerits of the case. But the important point for this court is just how important this...
Mr. Parker, under the governor's broad view of her powers during the emergency pursuant to the Emergency Management Act, so it would be logical to assume that her position would be really that the legislation that's at issue in this case, the immunity legislation, was not even necessary.
It
She
was
could abrogate their right to sue without further legislation from the legislature.
I think so. The way I would analyze that, Justice Mendham, is that the proclamation was in effect at the time of the incident,
Right.
and so that would preclude the case, some of the claims. The legislature then, in February, just a few months after the incident, came in and retroactively provided immunity consistent and in pari materia with the governor's proclamation.
But it would be your position or the governor's position that wasn't necessary for the act to come forward because her proclamation dealt with this issue.
Well, to quibble only a bit, the governor did sign the Immunity Act that's also in play here, and she believed it is a very good policy
veto
for the
at
state.
one or the other, right?
I'm sorry.
But it was unnecessary.
I think that in this particular case, it probably was unnecessary,
Okay.
but it certainly.
Or do you think that they all go together, the safe harbor, the legislation, as well as the governor's order?
Yes, you have multiple independent bases for giving these hospitals and healthcare facilities the insurances they need, which really gets to the core of the purpose of this particular proclamation. COVID-19 presented so many different scenarios. We issued emergency proclamations to help cut red tape for
I understand, Mr. Parker, but I think I've also heard you say twice that you said some of their claims. Is that correct?
That's correct. That's my understanding of the record. The governor's proclamations did a number of things to help all of society adjust to this new reality, including authorizing remote notarization of signatures on important legal documents, authorizing remote meetings of governmental entities and corporate shareholders and nonprofit groups. We postponed an election with the blessing of the Attorney General. The governor postponed the state tax filing deadline. This order in particular was important for a very simple reason. It's that there was a real fear that businesses and healthcare facilities, as we were being one of the first states to come out of the more restrictive measures, would clam up, in essence, out of fear of lawsuits. And so the idea behind this proclamation, which was negotiated, like many and most of our emergency proclamations, with stakeholders, including business in this case, and also representative of the trial lawyers. And so the idea was that we would give assurances to these important first responders in the healthcare settings and businesses to bring our economy back to life. It was not unlawful for Governor Ivey to help Alabama reopen the economy in this way. The action here at issue, the proclamation, it was on all fours with the Emergency Management Act. There was a state of emergency validly proclaimed. Don't understand anyone to have questioned the governor's determination on that point. And it was necessary, in the words of the statute, the Emergency Management Act, to protect the safety and protection of the civilian population. There was no separation of powers issue here. This is something that the legislature set up, and there was no suspension clause issue here as well, because the legislature itself suspended any contrary or inconsistent laws. There are certainly limits on these governor's Emergency Management Act powers. There are legal constraints, to be sure. There are also political constraints, as we know very acutely in the governor's office, and I don't think the governor would mind me pointing out that she won re-election, despite all of these events. But the legislature made these powers broad for a reason, to give Governor Ivey and her predecessors and successors the ability to take decisive action in an emergency to protect lives. So I ask the court, uphold the proclamation and act, but most importantly, to avoid at all costs any ruling that would call into question needlessly the validity of countless emergency orders that an Alabama governor has already issued or might want to issue in the future. So if there are no further questions, I will sit down.
Thank you, Mr. Parker. Mr. Lemoyne?
Counsel, what did the trial judge do?
Starting with the original motion for summary judgment, our response was a 56F and a motion to strike, because we had affidavits submitted against us that were unsupported by the documents they referenced, so that was the basis for the motion to strike. Also, we'd never had an opportunity to depose those affiants. So our initial response to summary judgment was just that, is, hey, this is early. We haven't been able to depose these people. These affidavits aren't proper. Let's ask for more discovery. The court initially rejected that position, but later reversed himself and opened the case back up. In our view, at that point, we have a clean slate. The case is reopened. We can go to conduct discovery. We can submit our own affidavits, and the summary judgment is argued anew.
And you argued below that all three immunity provisions were unconstitutional because they were they would have a retroactive effect. Is that correct?
Yes, sir. And to be clear, we are not disputing the prospective application of any of those statutes. Our argument is that the retroactive application is improper in this instance.
Okay, so you made that argument, and I assume the other side joined in.
Yes, sir.
Adverse to your position.
Yes, sir.
At some point, you were apparently called upon, or counsel below was called upon to draft an order for the trial judge.
Yes, sir.
Okay. Did he take the proposed order that y'all drafted and sign it?
Yes, sir.
Okay. What do you think he did with the constitutional issue?
That is a very good question. I will agree that it is ambiguous based upon that order, because the part of the order says
Sorry, did you provide the order to the trial court judge?
I did, Your Honor.
You did not.
I did, yes, ma'am.
You did.
Yes, ma'am.
But you didn't. You also did not touch on the constitutionality issue?
Your Honor, I provided that order to the court based upon what I anticipated he wanted from us rather than my dream order result. And so, yes, ma'am, we sent that to him for his review.
So there's no mention of the constitutionality, retroactively, prospective, or anything in the order, is that correct?
In the order, there is no specific mention, but in application, in adopting 793, the order essentially finds that 792, 794, and the governor's proclamation do not apply. And that's why I said it.
So the constitutionality really isn't before us, is that correct? I mean, it's a writ of mandamus, right? So we're limited to what went on. We've got an order that you drafted, and the constitutionality questioning either the proclamation or the legislation isn't there. So how is that even before us?
Well, those issues were certainly argued, as well as the potential implication from the court's order in finding that those do not apply. He is necessarily ruling that they are invalid or unconstitutional, otherwise they would apply.
But did he say in the order they were unconstitutional?
He does not.
Okay.
And you know, words have meaning.
Yes, ma'am.
As a lawyer.
Absolutely.
And we can't assume what the trial court judge thought or was doing.
100%.
Understand this predicament that we're in.
Yes, ma'am.
Counsel, can I ask you, I see three immunity provisions here. I know they've been referred to as a safe harbor or an exception. I just prefer to see three immunity provisions, 792, 794, 793.
Yes, sir.
You make the argument below, none of these are applicable. They're unconstitutional as applied.
Yes, sir.
Okay.
Based on the retroactivity.
Okay. But the trial judge chooses not to say anything about constitutionality, but he picks one of those immunity provisions to apply, I mean, at least to look at, and he pulls an exception out of 793 and says, okay, this is an exception to the application of immunity in 793. You got to explain to me, I don't understand how did he just say that 792 and 794 were unconstitutional? He was going to analyze 793, or did he say all three were unconstitutional? However, he goes back to a provision that he has just said is not valid and has no place in the discussion, and he pulls out an exception and says, well, that exception eliminates any. I am confused about what was ruled on in the trial court.
Yes, sir, I agree that those positions are in conflict. I don't know that there's a better way to explain that, because in our mind, retroactively, none of them apply, and so how can we apply an exception from 793?
And the reason that's important, not only for your position, but also for a petitioner's position, is that the petitioner sees the trial court's order one way and then frames the petition a certain way. That petition does not raise the constitutional issue or bring it up whatsoever. The petitioner is arguing about 792, 794, and he's arguing that those two provisions are the threshold question. You don't even get to 793 unless 792 and 794 don't apply.
Yes, sir.
And then if they don't apply, you move over here, and then they're talking about what immunity is available there. It's, their argument, it's not an exception, it's just another extension of the immunity provision. So where that's important for us, normally you have to raise an issue in your mandamus petition. They don't raise it based on what they perceive the argument to be. I'm sorry. You raise it up here. You bring it up again. They don't address that specific argument in the reply brief. They talk about the proclamation. So we're two ships passing in the night here on this constitutional issue. So I'm left to wonder, are we looking at this constitutional issue as properly before us? Are we looking at it as an alternative means to uphold the trial judge? And what is the standard there? You understand?
Yes, sir.
What is the standard there? I don't have an argument from the other side that is in rebuttal to your argument in your answer. In order to get a rebuttal argument from your answer, I have to go to the BCA brief and the Attorney General's brief, and I need some guidance from both sides as to whether this constitutional issue is properly here, and if it is, what can we consider in trying to make a decision on whether Section 13 applies here and this retroactivity defense is actually a good defense? So if you could sort of zero in on that.
Yes, sir.
Setting aside the wantonness and the sufficiency of the evidence and that for purposes of this, if you could zero in on that, I would appreciate it.
Yes, sir, and also setting aside the discussions of the proclamation as well.
I wish you would. Just for purposes of my question, just set that aside.
Yes, sir. So I think that there is authority for this court to address the constitutional issue when it is briefed before the court and raised by us, even sua sponte on the court's own motion. There's a case that is State ex rel Bland v. St. John, which is a Supreme Court case from 1943. And if I may, I'd like to read an excerpt. That case deals with this.
Give us the site for that.
Yes, ma'am. It is 244 Alabama 269. And this was a case out of Coleman County during the war, the Second War, when there was a question of whether someone could be in the Army and hold office under the state law at the same time. And there was a constitutional question that was briefed by both parties but was not in the order of the trial court. And the Supreme Court at that time said, "It is true that this case can be decided without going into the constitutional questions, but we believe that the merits of the controversy before us cannot be completely determined without a consideration of such questions. The constitutional questions have been exhaustively briefed by both parties," and I recognize maybe not by Jackson Hospital on that point, but there's certainly briefing to that point for the court to consider. "And in view of their manifest public importance and of the fact that an ultimate decision of them must sometime be arrived at in this court, we shall proceed to a consideration of whether the entire act is unconstitutional by reason of the alleged unconstitutionality of various sections thereof. The writer conceives it to be the duty of this court, where an inspection of an act inspection of an act indicates its constitutionality to so declare and dispose of any supposed conflict. So while it may not, because of the trial court's order and some of the things that have gone on, be perfectly teed up before this court, should the court choose to do so, I think there's precedent there that would allow the court to consider the constitutional issue.
Okay, so basically, your argument, if I could just paraphrase, your argument would be, normally constitutional issues are of such importance to us that we don't approach them unless we've got really good briefing on it and we can really do a deep dive into it and make sure that we are going to get it right. But what you're saying is, even though we have an absence of briefing in the petition on it, we would be permitted under certain precedent to allow that absence to be filled in by amicus arguments from the Attorney General, BCA, and take your briefing on that. That would be sufficient, you think, for us to reach this constitutional issue? It's a pretty weighty issue, and so I'm trying to, is this a balancing?
Your Honor, I think that's where the earlier questioning regarding their failure to address it in their reply brief comes in.
Well, do you think perhaps they didn't address it because the trial court order didn't address it?
Again, the trial court order could be read to have invalidated 792 and 794, and we certainly raised it in our answer. At that point, the opportunity for reply is there.
Thank you.
Do we have any other questions on that point?
None on that. Thank you.
And again, our plan today was for me to address the proclamation and Mr. Lattimore to address retroactivity. And I would love to continue.
Can I briefly, could you address Judge Poole ruled, granted summary judgment for the hospital, and within 42 days you filed a notice of appeal of that order. Jurisdiction came to us. Under our law, that would strip Judge Poole of further jurisdiction. Then for the next 2 or 3 years, y'all continue to litigate this matter while the notice of appeal was still pending. Your notice of appeal.
Yes, sir, and I would need to refresh my memory on those exact proceedings. The question...
July 22nd, 2022, you filed a notice of appeal. Judge Poole's order.
Yes, sir, no question.
Later attempted to set it, which I understand why you did that. You were going to run out of time, but...
Right, out of an abundance of
that's
caution.
That's going to strip the trial court of any further jurisdiction.
It does unless the parties and the trial court specifically agree that they are continuing jurisdiction for certain purposes.
I think I disagree with that point. Once it's with us, even if it's improper, it stays with us until either we dismiss it or the appellant withdraws it, other than completely ancillary matters like supplementing the record or things of that nature.
That is correct, obviously. If matters, essentially, I filed the notice of appeal under an abundance of caution.
Understand.
While he was still considering our post-judgment motion.
Once you file it, that strips Judge Poole of any further authority to rule on this case, typically under our case law.
And we requested originally that be held in abeyance while he resolves those issues. Ultimately, it was sent back on that.
I think a couple years later, you actually dismissed your notice of appeal.
And again,
after all the litigation occurred.
If I may review those
That's fair.
briefly, Your Honor.
All right.
Thank you.
Mr. Lattimore?
Yeah. Chief Justice Parker, and may it please the court, my name is Will Lattimore. I also represent the estate of Nathaniel Johnson. I'd like to kind of dive right in and get to the substance of what the court's been asking about here today. I think that a lot of this can be cleared up by looking to the retroactivity principles that were before Judge Poole. Okay? When a law retroactively affects a vested right, if it eliminates a cause of action retroactively, well, then it is presumed to be invalid. And we're going to get into, hopefully today, some pretty detailed and thorough case law that goes directly to that.
Mr.
With
Lep,
it-
can I
yes, sir.
can I interrupt you before you go down that road? I guess I've thought through the constitutional things, and I guess I have a question about the wantonness claim in here. And also, there was testimony there. This is a respiratory therapist issue that went on here. The testimony that you, as the plaintiff, put on was from an expert that was not, and it looks like not a respiratory therapist or similarly situated. How do you get over that hurdle, and is it possible for us to get to the wantonness claim, as the petitioner suggests, that we can go ahead and completely rule in this case?
Justice Sellers, that is an excellent question. The reason we can address wantonness here is because Mr. Johnson was taken off of a BiPAP machine when it was undisputed that he was incapable of breathing without one. There is law from this court, clear law from this court, that when, even within the context of the Alabama Medical Liability Act, when a breach in the standard of care is something that is understood by the average individual, that is understood by lay people as being an unreasonable danger, that is something that does not require similarly situated expert testimony. The expert testimony Your Honor refers to actually comes from I believe the director, the medical director of Jackson Hospital, of the defendant himself. It is not as though any expert similarly situated respiratory therapist was disclosed to the trial court. And the trial court heard that and understood that to mean that, hey, this guy was taken off of a BiPAP when it is undisputed that he can't breathe without one. There is affidavit testimony from Mr. Johnson's wife, Theresa Johnson, who herself is an employee of Jackson Hospital, who's no stranger to the medical field, who was present there, who says that no other mask was put on him.
But the therapist, don't we have affidavits from 2 respiratory therapists who said once he was taken off of the BiPAP machine that an oxy mask?
There's a dispute of fact as to that issue, Your Honor. That's correct. We're here on a Rule 56 where those disputes are to be reasonably resolved and reasonable inferences are to be drawn in the plaintiff's favor. But you're correct that there is affidavit testimony from respiratory therapists who say that. I would like to get back to the procedure.
Let me just ask you, I appreciate that, and I've been in your position before, but I guess I'm trying to sort through and talk about standard of care, and maybe this will get you back into your argument retroactivity.
Sure.
You know, we've got a COVID crisis going on. We've got issues that you can't get certain machines, the hospitals, understaffed, overloaded, or whatever it is. How do we arrive at a standard of care in an emergency situation when everybody's, I'm not going to doing basically the best they can, limited resources, limited staff, and all that? How do we derive a standard of care?
It was a unique circumstance. You're absolutely right. That's why we had alternative standards of care. And the alternative standard of care at that time, from the hospital's own testimony, was to have individuals, respiratory therapists, remain present, one, with that individual when he's taken off a BiPAP machine to be transferred from room to room, and two, the oxy mask has to be applied. There's got to be some inline filter in place for that individual at that time. And that was the alternative standard of care that Jackson Hospital has testified applied to them. And that's what we have evidence was breached. So that's a fantastic question. There were alternative standards of care. That's what Section 793 really gets at. There's a distinction between 792 and 794, which flat out eliminate otherwise viable causes of action resulting from injury or death that is proximately caused by someone else's negligence. That's 792 and 794. That's their effect, no doubt about it. 793 is different. 793 is more limited. What 793 affects is a remedy, primarily. What 793 says is, look, you only get economic damages if there's no serious personal injury that results. That's what 793 says in part. And then other than that, 793 says, look, the claimant just has to provide clear and convincing evidence that the covered entity did not reasonably attempt to comply with the then applicable public health guidance. In other words, the alternative standard of care that applied during this very unique, to all of us here, pandemic, okay? 793 did not flat out eliminate a cause of action. There's a question as to the extent to which it really altered the Alabama Medical Liability Act. It just said you've got to prove by clear and convincing evidence, which is already required under the Medical Liability Act, you've got to prove that they deviated from.
Doesn't 793 only come into play if you don't have 792 and 794?
Exactly right. Exactly right. And that's where I think Judge Poole was going. when you got 792 and 794 were, of course, enacted after Mr. Johnson's death. The legislature had not passed that law at the time Mr. Johnson passed away. But what 792 attempted and 794 attempted to do was to retroactively eliminate a viable cause of action. That's something that is disfavored at the federal level, and it's even more strongly disfavored here in Alabama. In Kaiser Aluminum, Justice Scalia famously wrote that the presumption against retroactive legislation is deeply rooted in our jurisprudence. It embodies a legal doctrine centuries older than the Republic. It has timeless and universal appeal. This court has held in City of Bruton v. White's Auto Store that statutes that impair vested rights are, quote, odious. Go ahead if you've got a quote.
So, what do you think Judge Poole did with 792 and 794?
He held that they cannot apply retroactively.
He held them unconstitutional.
Correct. 793, and I think the legislature saw this coming, frankly. 793 of these various code sections. 793 is the one that explicitly says, hey, regardless of the date of the cause of action's accrual, we're going to apply this, 793, okay? They knew that eliminating viable cause of actions in 792 and 794, there was a possibility that that would be held unconstitutional. And that's what I believe Judge Poole did. And that's why all that's left standing is 793. When an act only affects a remedy as opposed to a cause of action, then it's whether or not it can apply retroactively is governed by a different standard. There's an absolute bar in this state on retroactive application of laws that eliminate causes of action. When the remedy is only affected, that's different.
But given the governor's proclamation, did you really have a vested right at that point?
Yes, we did, Your Honor. Yes, we did, because the other governor's proclamation exceeded her authority under the Emergency Management Act. Her authority, and listen, I agree with Mr. Parker on this point. We want the governor to be able to step in. We want our executive to be able to step in and use her executive authority to protect the health and safety of Alabamians during an emergency. And there's no doubt, if there was ever an emergency, the COVID pandemic was it. But her authority under the Emergency Management Act is limited to those actions.
Bring that up to the trial court?
Yes, Your Honor. Okay. Her authority in that circumstance is limited to those actions which are, quote, necessary to protect the health and safety of Alabama citizens. That's where the line's drawn. It has to be for the health and safety of Alabama citizens. And the vast majority of her orders during that time did exactly that. They reduced in-person contact. They authorized an alternative standard of care, which created broader treatment options for medical providers.
Can I stop you there about the alternative standard of care? Because I'm really having difficulty, and this goes back to whether or not there are disputed facts. We have 2 affidavits from respiratory therapists. It said after the bypass was taken off, they went to the oxy mask. Then you have someone who is not a similarly situated individual. And I understand if you breach the standard of care, perhaps you do not have to have a similarly situated individual testimony as to that. But we have an alternative standard of care here. And I don't know under the alternative standard of care that it was breached. So we're now left with, did we have a similarly situated individual testify as to the breach of a alternative standard of care? And if you lose that, then there's no disputed facts.
If we lose that, there would be no disputed facts. What we have in this case is an admission from the defendant that the alternative standard of care required the oxy mask to go on. And now what we're left with is just a straight up question of fact from eyewitnesses who were present. Was the oxy mask put on or wasn't it? And when there's testimony from an eyewitness that says it's not, coupled with an admission from the defendant that says that the alternative standard of care requires it, that's what gets us past summary judgment this way.
Thank you.
Mr. Lattimore.
Yes, Your Honor.
Dr. Cunningham testified in his deposition about the existence of this alternative health guidance. but I didn't find it anywhere in the record. Was it ever submitted as a printed document or only through that testimony?
I believe and would need to go back to confirm this, and will be happy to submit a letter brief pointing to the specific page and line for the Chief Justice. But I believe that Dr. Cunningham's deposition testimony was attached as an appendix to one of the parties' briefs on this appeal. And I apologize, I can't cite the page and line
My
today.
question doesn't go to his deposition, but to the alternative health guidelines that they adopted in the hospital. Did those ever get submitted in printed form in the record?
I've been more involved in the appellate process. I would be happy to submit in a letter brief to the page and line on that. If it was, the fact that that doctor testified to it in his deposition, I think is relevant both to Judge Poole and to this court. But to your question, if it was the actual written out alternative standard of care is in the record, I'd have to submit that on a letter brief. Thank you. The Emergency Management Act, the governor's powers under that are limited to those that are necessary for health and safety of Alabamians. And like I said, the vast majority of her orders went to exactly that, either by broadening the treatment options available to medical providers or by decreasing in-person face-to-face contact. She adopted the Alabama health officer's Safer at Home order, which again reduced public gatherings. The one act that she did that ran contrary to either of those things was this order.
And how exactly did she exceed her authority in that particular order, and how did it relate to your specific claim in this case with the death of the decedent?
Yes, Justice Sellers. She exceeded her power in that order by entering an order that did not address health or safety. And let me explain how that occurred, how that happened. So this order was one that was aimed at economic stimulus, period. It was not aimed at decreasing in-person face-to-face contact. It was frankly, openly concerned with increasing it, with getting people back to the workplace and making businesses money and allowing businesses to make money, which is an economic, look, we love a healthy economy. We want a healthy economy, but that's the province of the legislature. It's not something that the executive can do unilaterally just because there's an emergency happening. I
also don't think you can say it was done just for economic stimulation. I mean, it also involved workers getting back to work and having families have money in their pocket. It wasn't just for businesses.
So is that then a health and safety reason, is getting money in their pockets? The Emergency Management Act is very limited in terms of what the governor can do, and we want her to be able to address health and safety. But imagine the implications. If an executive could enter an order during an emergency that says, hey, this is aimed at making somebody money, and I'm allowed to enter this order unilaterally because an emergency is happening. Imagine what the result could be. If a governor declares that, hey, my buddy who's a contractor is going to give jobs to people
I think we're
fix
straying
tornadoes.
way beyond the hospital malpractice claim. But
I agree.
But
I withdraw my question.
To this, we certainly would not want, and the governor nor anybody else during the pandemic that I guess all of us lived through, for the hospitals to say we're not going to treat anybody because we cannot comply with the typical standard of care. Hospitals didn't do that, so they came and they sought and they received some assurances from both the governor and the legislature.
The alternative standard of care was authorized by a separate order from the governor. And like I said, we do not challenge the governor's ability to authorize an alternative standard of care because that broadened the treatment options available to medical providers and allowed them to stay in business. There is not one single word in this record that suggests that hospitals were going to shut down because of the threat of lawsuits. The only new form of treatment that this order provided for was negligent treatment. That's it. Treatment that was in violation of the alternative standard of care, in breach of that, and not just in breach of that in a way that was harmless.
It goes back to aren't we sort of circling around on the constitutional issue because you still have the wantonness claim.
That's right.
So the legislature did not completely abrogate your cause of action for wrongful conduct during the state of emergency.
But
would it not be constitutional under that basis.
It abrogated enormous viable claims. This court is very familiar with the Spring Hill opinion, which was a negligence case where this court reviewed the facts on appeal. Very familiar with the Bednarski versus Johnson opinion, which was our firm's case.
I mean, what are you saying?
Those were both negligence claims, and it would only take a very small tweak to the facts in those claims for them to be absolutely abrogated by what the legislature
If the
attempted
jury
to do.
were to agree with your client's affidavit, wouldn't that amount to wantonness?
Well, I certainly agree with that.
And so therefore you have your cause of action,
That's
regardless
right.
of whether negligence has been abrogated.
A negligence claim, though, is not a minor thing. It's just something I would point out. It's something
I'm not saying that, but still, if I think most people in reasonable juries, if you cross that threshold point that you're believing what your client says, that would amount, I think our court would uphold a wantonness verdict. So it's a moot point whether negligence.
The legislature, I think, acknowledged that negligence claims are of huge importance in 799 when they held that this abolition of those claims was going to expire on a specific date. I mean, negligence claims have been a right of Alabama civilians since we've been a state. So I don't think it's a minor thing to just say, well, we're just going to increase the bar to wantonness. I do think it's...
I'm not suggesting, in fairness to me, if I can have a right of rebuttal, Chief Justice, that I'm suggesting that negligence is a minor claim. I certainly am not, and I think the video will show that I never suggested this.
I apologize
but I am phrasing it in the context of of what was going on at the time, and to say there's a mass casualty event, and medics and firefighters have to make decisions on who to save and who not. You know, they can't be caught back in the situation of being sued for negligence after the fact. So anyway, it's probably best that we just
we can agree that that might be a reasonable opinion. It just is an opinion that can only come from the legislature, and it has to be applied prospectively. But thank you.
Thank you, Mr. Lattimore. Madam Clerk, they did run over a little time, so would you add that time to Mr. Ritchie's rebuttal?
Counsel, not to throw you off guard before you even get up to the podium, but I am. For the moment, let's forget about retroactivity. Let's forget about the constitutional issue. Just take it off the table. Please walk me through how 792, 794, 793 operate as you say it operates in your petition.
Certainly, Your Honor. We say that 792 and 794 are independent of each other. 792 providing immunity as applied here for a hospital treating a patient with COVID. That is a claim that arises out of the pandemic. It is a healthcare covered claim under the terms of the statute and falls within the ambit of this court's decision in the ex parte triad case. Second, under 794 provides an additional layer of immunity when a hospital can demonstrate, in this case at least, that a hospital can demonstrate that it's operating under restrictions that were caused by the pandemic. For example, a shortage of filters for a BiPAP machine that required removing Mr. Johnson from the BiPAP machine in order to transport him. Because we did not have any of those filters available, he had to have an alternative source of oxygen provided to him and able to allow him to be transported to a higher level of care. So that's the distinction between 792 and 794. And then 793 is the fallback provision that says, setting aside those two layers of immunity altogether, there's a safe harbor where if a plaintiff cannot demonstrate by clear and convincing evidence that the healthcare provider is not at least reasonably attempting to comply with applicable healthcare guidance, then the healthcare provider is also immune. They can know prospectively, if we're trying to comply with the guidance, we're protected. So it's a prospective standard of care.
Mr. Ritchie, I want to ask you a couple of questions. First of all, was triad a plurality decision?
It was a plurality decision. However, the decision to apply the statute to the slip and fall claim in that case was unanimous.
Help me out here. It seems like, going back to some of the questions Justice Shaw was asking you when you were first up, these constitutional issues are in the atmosphere here. You didn't brief them or raise them in your petition. There does seem to be kind of ships passing in the night as it relates to the constitutional issues, although we have some very good briefing here on with the amici. Why shouldn't we just deny your petition and allow the trial court to take the first crack at the constitutional issues? I know that Judge Poole obliquely, I think, made one statement in the trial court order that even said anything about the constitutionality, but why not just send it back, let the trial court take the first crack? If he finds it's unconstitutional, then bring it to us. If he finds it's constitutional and then deals with the immunity questions, y'all can hash that out and then bring it to us if necessary. Why shouldn't we just dispose of the mandamus petition in that way?
Your Honor, I don't want to make a joke, but the correct approach there would be to grant our mandamus petition and find that we fall within the scope of the COVID Immunity Act, and then to send it back and allow the trial court to address an issue of validity if that is how the court is determined to proceed. We unquestionably do fall within the scope of the act, as raised in our petition, and certainly in light of the ex parte triad. The majority, the unanimous decision of this court, if not all the justices signing on to majority opinion.
Can you walk me through how Judge Poole would declare 792 and 794 unconstitutional? So he said, impliedly, assuming he says, I agree with them, it's unconstitutional, they don't apply, period.
Yeah, so
Can he then just go to 793? I mean, I've understood that they made the argument that all three were unconstitutional because all three of them are going to be retroactively applied. How does he go from declaring two unconstitutional, skip to 793, and then get to the point of saying there is no immunity whatsoever?
So I think that he misconstrued the statute, and I think that the plaintiffs have misconstrued the statute. I don't believe that that is an option that was available to him, nor do I think that that's what he did. His order is unambiguous. The final sentence reads, "The court need not and does not hereby rule on the constitutional issues or wantonness exception raised by the plaintiff." There is no way to interpret that order as deciding any constitutional question, impliedly or otherwise. He engages in no statutory construction, no constitutional analysis of anything except for 793. And the only thing that we believe this order raised and allowed us to raise at mandamus is the scope of immunity as applied and as constitutional.
So what you would be asking us to do is to grant the writ, rule on the applicability of the three immunity provisions as you have discussed in your petition, grant the writ, and send it back down. Can the constitutional issue be raised at that point? He hasn't ruled on that.
True, he has not ruled on it. It's been briefed. I do have concerns about jurisdiction that I believe were raised by Justice Mendham, and I don't want to...
I'm sorry, I would like you to address that, whether
Certainly.
or not the trial court has lost jurisdiction once the notice of appeal was filed. So what is your position?
Well, we've layered two questions on top of him. Mine was mine was different, and that is Justice Mitchell had asked about us making a ruling of some kind that would then put the ball back into the trial judge's court on the constitutional issue. Is that what you're asking us to do?
I'm asking the court to do what our petition originally said, which is construe the ACIA and to find that the trials court misconstrued it and grant that provision. Now, there would still be a claim pending if this court does not reach the wantonness question, which falls outside of the scope of ACIA immunity. That would send the question back to the trial court.
Okay. Did he misconstrue it, or he just didn't address it?
I believe the trial court misconstrued the statute by not applying Section 792 and 794 and then not correctly applying Section 793. He interpreted the safe harbor provision instead to be an exception to immunity instead of a further layer of protection for healthcare providers. Justice Wise.
Well, it was actually Justice Mendham who brought it up. So
Certainly.
Wait, so I'm gonna so on this wantonness issue, you in your petition indicate that we don't even need to get to the wantonness issue because it's clear, and I would like for you to think through that and then help me understand this issue about the similarly situated respiratory therapists, because I've been concerned about that, and that's a little bit more of the meat of the matter, but could you briefly address that? I know your time's limited, and I appreciate it.
Certainly. Justice Wise, can answer to your question regarding appellate jurisdiction. Our understanding is, and it's not entirely clear from the record, that the plaintiffs did request, when they were the appellants, that the court hold their appeal in abeyance. I do not see an order that grants or denies that request. We have cooperated with the plaintiffs to bring this case, to join issue with it, and have done so in a spirit of professionalism and good faith cooperation. And I don't want to go back on anything that we have through trying to bring this case in an orderly fashion before the court. But if there was no jurisdiction, then it's unquestionable that jurisdiction doesn't exist if it's vested here through that notice of appeal. And I don't see anything in the record that I've reviewed that suggests that did not happen.
If we were to agree with everything you say in your petition, what would you have us do with the argument made here to us that was also made to the trial judge that these provisions are unconstitutional? That is what is. I can't get clarity on this because you're asking me to take 3 sections and say you win. I don't know. I think I know what the trial judge did, but I've got this argument that they're just blatantly unconstitutional, and I've got amicus arguments making very good arguments by this side too. What is the court to do with the constitutional issue?
And that's laying aside that issue about whether it's an appeal or not. You know, the
I'm
earlier
talking
appeal.
about whether there was an appeal. I just want to know what to do with that issue. What do you think?
The most orderly thing to do would be to decide that the statute applies and to send it back to allow the trial court to address the constitutional questions. If the trial court should find the statute invalid, we would be back before the court either on mandamus or potentially a final judgment. I will notice the decision that was cited by Respondent's Counsel. We haven't had a chance to review it yet, but the style of the case would suggest that it was not a mandamus petition, and an appeal from a final judgment would certainly carry up every issue in the case. The mandamus petition does not carry up every single issue in the case. The constitutional question unquestionably was not decided below.
Are you talking about the St. John case?
Yes, that's correct, Your Honor.
It was ex parte, right?
I thought it was state ex rel. To address the standard of care question, I feel like I'm always one question behind. Alabama statute is very clear on this issue. So under Section 65548, you have to have similarly situated expert testimony to establish the standard of care. The plaintiff does not have, the individual plaintiff herself, she does not possess that expertise. That's without question true.
Okay. Do I need an expert to say whether a mask was put on or not put on?
You would need an expert to say whether a mask was required or not.
That's not my question. Do I need an expert to say, was the mask put on or not put on?
The fact, no, you do not, Your Honor.
Not in that the question?
No.
I'm not talking about, I get where you're going with the standard of care, the health care standard of care, but I think the real issue here, isn't it, was a mask put on or was it not put on? And I think any individual could not, an individual to say it was or was not.
Your Honor, respectfully, I disagree with that characterization because the plaintiff had been in the hospital, I believe, since the 26th of November. It's now the 6th of December. I'm not sure that, the decedent had been in the hospital for that time. I don't believe that he had been receiving supplemental oxygen at all until the 6th of December, and the testimony in the unrebutted medical records show that at all times he was on some form of supplemental oxygen, and that Dr. Cunningham, who was the plaintiff has referred to as an admission by the hospital, was a doctor who said very clearly that he is not giving an opinion about the standard of care as it relates to respiratory therapists. He denied any knowledge of that. I see that my time is expired.
But we have one more question.
Certainly.
No, I don't have a question. I just wanted to tell you gentlemen that we have taken you off your game. We have grilled you pretty strenuously, and you have done a marvelous job. We appreciate not only how you have responded to all of our questions and been so flexible in doing that, but we also really appreciate the fantastic briefing that y'all have done, and we appreciate it.
Is there any possibility, I might be pushing my luck, that I can read one statute? That was going to be the first thing that I read before I was off my timing. I'm happy if I need to sit down.
Was it in response to a question that was?
Yes, it was. Just wanted to raise very quickly the scope of the AEMA. There was a suggestion that it related narrowly. I just want to read the provision as I have it here in my notes. This is Alabama Code Section 31-9-8A5. It says that in addition to all other powers, the governor shall have the power to perform or exercise such other functions, powers, and duties necessary to promote and secure safety and protection of the civilian population. It's very broad. Thank you.
I had one, and actually it's for both. Does this court need to vest jurisdiction back in the trial court because of the appeal that was filed after the summary judgment? Because if the trial court has lost jurisdiction at that point, what we have is an appeal of the summary judgment, and that's it.
My understanding is that appeal has been dismissed, Your Honor. It is no longer pending before the court. Thank you.
Thank you. Well, our thanks to all of the parties on this. This is, you can see from the questions up here, this is a challenging case for us. We thank you for helping us with this. And with that, and we stand adjourned.
All rise. Court is now adjourned.